Hi everyone, I am Kanchan and today we'll be studying more about the Consumer Protection Act. So, today our focus will be on the various authorities which are included under the Act. So, let's start. First authority is the Central Consumer Protection Authority, which is also known as the Central Authority. Now, in the introductory lecture, as I have said, that this is a new body which has been included for the first time and it is a regulatory body. So, I believe that inclusion of such a body in the Consumer Protection Act will completely revolutionize the consumer movement in India because it is having a number of amazing and very strong powers which will bring into effect the consumer movement in a positive direction. So let's start reading about it. We have chapter 3 dealing with this authority and section 10 to section 27 direct towards this particular authority. Okay, and its purpose is to regulate, protect, and enforce the interest of the consumers and matters that are related to unfair trade practices. The power to inquire and investigate, which is there in section 15. So, what can the central authority do? The central authority, it shall have an investigation wing. So, altogether, a different wing which will be attached to the central authority, which will be headed by the Director General, and then the central authority can direct or it can ask, it can mandate the Director General of the investigation wing to start any inquiry or investigation under this particular act. Second, and the most important power is the power against misleading advertisement, which is there in section 21. So, this is another significant power, and it means that now the authority has the power to take action and it can impose penalty against the misleading and false advertisement, and most importantly against the endorsers as well. So now you can see that even the celebrities who will be endorsing any misleading or false advertisement can be punished under the particular act. So be it Madhuri Dixit or Amitabh Bachchan ji, who have endorsed the products like Maggie, and then Maggie was into a lot of controversy. So therefore you can now say that anyone, any celebrity, any important personality who endorses such product would be punished. Let's see what's the penalties. So for the manufacturer, it could be jail up to 2 years with fine up to 10 lakh rupees for the first offense, and for the consequent offense it could attract jail up to 5 years with fine up to 50 lakh rupees. For the publisher or the advertiser, it would be 10 lakh if Central Consumer Protection Authority finds the publisher or the advertiser also guilty. And again, endorser up to rupees 10 lakh, fine, and 1 year ban on future endorsement for first offense. If they repeat the offense, then the fine could be extended to rupees 50 lakh and a ban on future endorsement up to 3 years. So you can see there are very stringent provisions now. If we particularly come to the law, that is, which particular section gives such powers and authority to the CCPA or the central authority, there is section 18. So, section 18 you can say is the repository of all the major and vast powers given to central authority. So, what does it say? Let's read. It says that the central authority shall protect, promote, enforce the rights of consumers as a class and prevent violation of consumer rights under this act. See, it has to play a preventive role also. Okay, so this is a new step altogether. Earlier, there was no such authority. So we have only the redressal commissions, like once an offense is committed or once the consumer has suffered any harm, damage, then you can go to those forums. But preventing the harm altogether is a new step and it's really welcomed. Second, to prevent unfair trade practices and ensure that no person engages himself in unfair trade practices, we'll see as to what constitutes the unfair trade practice when we'll be reading about the adjudicatory process of these authorities. Third is ensure that no false or misleading advertisement is made of any goods or services which contravenes the provisions of this act or the rules or regulations made thereunder. Okay, so this is again a preventive measure against the false or misleading advertisement. Then ensure that no person takes part in the publication of any advertisement which is false or misleading. Another corollary power or function. Okay, so you can say that A, B, C, and D. There are four preventive powers or functions of the central authority, and you can remember them easily because C and D are related to misleading advertisement, and A is general. We have to protect the rights of the consumers, and another one is to prevent happening of any kind of unfair trade practice. So these are the four preventive powers in 18.1 A, B, C, and D. Now, the subsection 2 says that without prejudice to the generality of the provisions contained in the subsection 1, the central authority may, for any of the purpose aforesaid, now to bring into effect the powers that are being given in 18.1, there are powers which are given in 18.2. What are they? Okay, so to completely obtain, or you can say fulfill the purpose of 18.1, there are subsequent powers which are given in 18.2, or you can say in 18.1 there are functions that are to be performed by the central authority which are more in the nature of preventive functions, and to do those functions 18.2 gives the central authority the power. Okay, so you can say 18.2 is more about the power, 18.1 is more about the functions. So one says 18.2a, inquire or cause an inquiry or investigation to be made into violations of consumer rights or unfair trade practice, either suo moto or on a complaint received or on directions from the central government. Now here you have to remember that the Central Consumer Protection Authority will not come into direct contact with the consumers. It is, you can say, because it is a regulatory authority, so it will be an intermediary between the government and the seller or the manufacturer or the trader. Okay, so it is acting as an umbrella that will protect the consumers before any harm reaches them. Okay, so A is to inquire or cause an inquiry or investigation, and in section 15 we have read that they have an investigation wing which is headed by the Director General, and whenever there will be a direction from the central authority, that investigation wing will inquire or investigate. So when this investigation will be done, number one, it could be done suo moto. Okay, second is when they receive any direction or complaint from the central government. Second is they also have the power to file the complaint before the district commission, the state commission, and the national commission, as the case may be. So they can even act as a complainant. They can even file the complaints. So it's not that they'll be filing complaint on behalf of the consumers, but supposedly if they come to know about any unfair trade practice, or if they come to know that there's any harm being caused to the consumers, or there are any misleading advertisements or publication of such things, then in that case they can file a complaint to the either of these redressal forums. Then C, they can intervene in any proceedings before the district commission or state commission or the national commission, as the case may be, in respect of any allegation of violation of consumer rights or unfair trade practice. So not only they can file the complaint, But even if they haven't filed the complaint, then they can intervene in any of the proceedings. Then D, they can review the matters which are relating to and the factors inhibiting the enjoyment of consumer rights, including safeguards provided for the protection of consumers under any other law for the time being in force, and recommend appropriate remedial measures for their effective implementations. So this is more kind of a advisory power, because it's just like that if they found that there are certain factors which is leading to the violation of consumer rights, then they have to control those factors, they have to provide safeguards against such factors. Then E, recommend the adoption of international covenants and best international practices on consumer rights to ensure effective enforcement of the consumer rights. So it's again a kind of advisory power, that they can recommend that if there is any international law that prevails, there is any international agreement or convention, maybe by the United Nations or any other agency of the United Nations, then it will ask the concerned authorities in India also to implement the same, to follow the same. Then can undertake and promote research. These are all you can say positive or kind of advisory kind of powers that are being given to the Central Consumer Protection Authority. Then they can spread and promote awareness on consumer rights, encourage the non-governmental organizations and other institutions working in the field of consumer rights, mandate the use of unique and universal good identifiers in such goods as may be necessary. So you can, that is how you can, because when it comes to remembering the powers and functions, there should be a particular method you need to adopt. So you see that A, B and C are more in the nature of negative powers. Like when we read constitution, we have fundamental rights, and we say that the fundamental rights are more in the nature of negative powers or negative rights that are being enforced against the state. And when we call directive principles, we call it to be positive rights being given to the people. So in similar way, you can remember that A, B and C are more in the nature of negative powers that are being given, that they can inquire, investigate, file complaint, intervene in any proceedings. Then rest of them are in the nature of positive ones, that they have to create awareness, they have to recommend the adoption of the international covenants, they can review the matters that affect the consumer rights, they have to promote research in the consumer protection area, encourage the NGOs and other institutions who are working in that field, then promote the use of unique and universal good identifiers, can issue the safety notices to alert the consumers, advise the ministries and departments of central and state government on consumer welfare measures, issue the necessary guidelines to prevent unfair trade practices and protect consumers' interest. Okay, so this is about the powers and the functions of the Consumer Protection Authority in general, section 18. So 18.1 is about the functions, 18.2 is about the powers that they need to exercise so as to fulfill what is being given in 18.1. Let's read about their other powers. So this is the power of central authority to recall the goods, which is there in section 20. Now, where the central authority is satisfied on the basis of investigation that there is sufficient evidence to show violation of consumer rights, or there is any unfair trade practice by a person, it may pass such orders as may be necessary. So these are the list of the orders which can be passed by the central authority. What are they? It can ask for recalling of goods or withdrawal of services which are dangerous or hazardous or unsafe, reimbursement of the prices of goods or services so called to purchaser of such goods or services, and discontinuation of practices which are unfair and prejudicial to consumers' interest. So all these three things could be done together. So because therefore and word is used, so you can remember that आप रिकॉल करने के लिए कहोगे, जो पैसा कंज्यूमर ने उस सर्विस या प्रोडक्ट पे खर्च किया है वो पैसा वापस करने के लिए, रीइंबर्स करने के लिए कहेंगे, और कहेंगे कि आगे से इस तरह की कोई भी अनफेयर ट्रेड प्रैक्टिस या कोई भी गुड या सर्विसेज जो हैजार्डस है, डेंजरस है, उसको सेल ना किया जाए या उस तरह की प्रैक्टिसेस में इन्वॉल्व ना हुआ जाए. ठीक है. Provided that the central authority shall give the person an opportunity of being heard before passing an order under this section. तो ये जो है हमारे प्रिंसिपल ऑफ नेचुरल जस्टिस भी है कि nobody should be condemned unheard, है ना, जिसे हम ऑडी अल्टरम पार्टम भी कहते हैं. एडमिनिस्ट्रेटिव लॉ में आप पढ़ोगे या आपने पढ़ा होगा कि किसी को भी आप पनिश नहीं कर सकते जब तक आप उस पर्सन को एक अपॉर्चुनिटी नहीं देते ऑफ बीइंग हर्ट. अपना पक्ष रखने की एक अपॉर्चुनिटी उसे भी मिलनी चाहिए. ठीक है. नाउ लेट्स मूव ऑन टू द अदर पावर. देयर इज अ पावर ऑफ सर्च एंड सीजर व्हिच इज देयर इन सेक्शन 22. नाउ व्हाट डज इट से? इट सेज for the purpose of conducting an investigation after preliminary inquiry under subsection 1 of section 19, the Director General or any other officer authorized by him in this behalf or the district collector as the case may be may, if he has any reason to believe that any person has violated any consumer rights or committed unfair trade practice or caused any false or misleading advertisement to be made, shall enter at any reasonable time into any such premises and search for any document or record or article or any other form of evidence and seize such document, record, article or such evidence. मतलब कि जब सेक्शन 19 के अंदर एक प्रमा फेसाई इंक्वायरी या इन्वेस्टिगेशन हो जाएगा, उसके बाद में जो है सेंट्रल अथॉरिटी डायरेक्टर जनरल को या किसी ऑफिसर को जो उसके बिहाफ में ऑथराइज हो या फिर डिस्ट्रिक्ट कलेक्टर, इनमें से किसी को भी जब लगता है कि देयर इज़ अ रीज़न टू बिलीव दैट कंज्यूमर राइट्स आर बीइंग वायलेटेड या फिर अनफेयर ट्रेड प्रैक्टिस हो रही है या मिसलीडिंग एडवर्टीजमेंट है, तो उन केसेस में उस प्रमाइसेस को में जाकर आप सर्च कर सकते हो और ये सारी जो आर्टिकल्स हैं उनको सीज किया जा सकता है. कैन मेक अ नोट और एन इन्वेंट्री ऑफ सच रिकॉर्ड or article or require any person to produce any record, register or other document or article. The provisions of CRPC relating to search and seizure shall apply as far as may be for search and seizure under this act. तो जो पावर CRPC में प्रिस्क्राइब्ड हैं, जो प्रोसीजर प्रिस्क्राइब्ड है, उसी तरह से यहाँ पर भी सेंट्रल अथॉरिटी जब सर्च एंड सीजर की अपनी पावर्स एक्सरसाइज करेगी तो वही प्रोसीजर फॉलो करेगी. ठीक है. ये सेक्शन 22. तो आप ये ब्रॉड पावर्स याद रखें. ठीक है. तो एक जो रिपोजिटरी है सारी पावर्स का वो सेक्शन 18 है. फिर इन्वेस्टिगेशन विंग की जब हम बात करते हैं तो सेक्शन 15 भी है, और उसके बाद में अगर मिसलीडिंग एडवर्टीजमेंट की बात हो तो सेक्शन 20. तो फिर वो उसके अलावा आप जब रिकॉल ऑफ गुड्स की बात कर रहे हैं तो सेक्शन 20 है. ठीक है. और 18 की हम बात कर चुके हैं, 19 की हम बात कर चुके हैं. ठीक है. तो ये सारे सेक्शंस आपको याद रखने हैं. 21 जो हम बोल रहे थे मिसलीडिंग एडवर्टीजमेंट, ये सारी पावर्स और फंक्शंस हैं मेजर, आप याद रखेंगे. ठीक है. तो एक अथॉरिटी जो है वो हमने कंप्लीट कर ली है. लेट्स मूव ऑन टू द सेकेंड वन विच आर कंज्यूमर प्रोटेक्शन काउंसिल्स. तो ये जो कंज्यूमर प्रोटेक्शन काउंसिल्स हैं ये पहले भी थी 1986 के एक्ट में, और यहाँ पर इनका जो कॉन्स्टिट्यूशन है वो भी सेम है, फंक्शन भी इनके सेम है, और इसको हम एक इलस्ट्रेशन के थ्रू और समझेंगे. ठीक है. तो सेक्शन 3 से सेक्शन 9 जो है वो चैप्टर 2 में कंज्यूमर प्रोटेक्शन काउंसिल से डील करता है. Now such councils are to be established at central, state and district level. So we can say it will be a 3-tier structure of these councils which will be present at each of these levels: district, state and central. And the object of every council shall be to render advice on promotion and protection of consumer rights under this act at the central, state and within the district. Now, for example, Ram, he is an engineer by profession. He shifted to Delhi. He bought a computer from Shyam. who is a dealer who gave him all guarantees and warranties. The moment he plugged in the computer, some noise came and the computer was shut down. He called up Shyam but got no response from him. So, after making many calls to him, he understood he was cheated of his money. Now, Ram could have gone to the courts, but knowing that the lengthy and the expensive procedure involved, he preferred not to initiate any action against Shyam. One day, while watching television, he came across a program on consumer protection. Now, Ram got interested in it and noted the address of Consumer Council, which was sponsoring the program. Thereafter, he contacted the council and talked about his computer affair. The council made him aware that there is speedy and inexpensive way to assert his right as a consumer, and that where and how a complaint can be filed for that. So this is the role that was played by the council. So council made him aware that there is a speedy and inexpensive way to assert his right as a consumer, how he can file the complaint, and that he need not hire an advocate for the suit, and assured him of any assistance he may need for the same. So this is the important role played by the council. So consumer councils, they are created to advise and assist the consumers in seeking and enforcing their rights. And we have consumer protection councils at all the three levels: district, state and central. Now let's come to the most important authority under the act, which we call as consumer forums, the redressal forums. And again, by way of illustration, let's try to understand that. Ram, who is a resident of Panipat district, he took his son Shyam to a doctor for eye treatment. Due to negligence of the doctor, Shyam lost sight of his left eye, and Ram filed a suit against the doctor in district forum, claiming rupees 4 lakh as a compensation. Now, the district forum dismissed his complaint on the ground that negligence of the doctor could not be proved. So, first he went to the district council. Then, second, Ram appealed to the Haryana State Commission against this order, and State Commission also upheld the decision of the district forum. So, he could not get any justice then. Now, Ram approached the National Commission and made an appeal therein. So, till now, he approached three authorities: the district forum, the state commission, the national commission. Then Ram knew that after National Commission also, he is still left with an option to approach the Supreme Court against the order of the Commission. However, the National Commission decided in favor of Ram. So, in case if National Commission would not have decided in his favor, then the last remedy was that he could approach the Supreme Court by way of an appeal, because the Act itself provides that the appeal from National Commission would go to the Supreme Court. So, please remember, this could be factual information also, that appeal will not go to the High Court, but it will directly go to the Supreme Court. Then there is a three-tier structure that is being explained through the illustration. Okay. Another important thing, that the district forum and the state commission, they are being formed by the states. Okay, so don't get confused that district forum will be constituted by some district authority. No, district forum and state commission, they are being formed by the states with the permission of the central government, while the national commission is formed by the central government. And these forums, remember, they have not taken the jurisdiction of the civil courts, but they have only provided an alternative remedy. So even in the introductory lecture, I have told you that the Consumer Protection Act is not an overriding act. Okay, so it just provides a supplementary an alternative or supplementary forum for the protection of your rights. Okay, so let's start with the first forum, that is district forum. And about each forum, we'll be just reading what's the composition of it, what are the qualifications of the members, what is their term of service, okay, and at later stage their jurisdiction. Okay, and what are the remedies that are being available to the consumers, and how do they exercise it, what is the procedure of filing the complaint, who can file the complaint, against whom the complaint can be filed, and all the other remedies, all the other procedure that can be taken recourse to. For example, now we have mediation also, we have the benefit of filing e-complaints also. So these are the new features in the act that we have discussed. So all that will be dealing in the next lecture. Okay, herein sorry, herein we are only concerned with their general structure of all these forums. Okay, so first is district forums and section 28 of the Consumer Protection Act 2019. Please remember, I am dealing with the 2019 act, so please don't be at all worried that what if the 1986 act is being asked. Even if the 1986 act is being asked to you, you have to write the 2019 act's provision, because as I said that nothing is being repealed. What is only done is that some provisions are being added. So it's better that we learn the new law instead of remembering the old provisions. Let's learn the new law. Okay, new provisions, new numbers. Okay, so section 28 says that the state government shall by notification establish a district consumer dispute redressal commission, which will be known as a district commission in each district of the state, provided that the state government may, if it deems fit, establish more than one district commission in a district. So this is a factual information that you can remember, that there can be more district commissions in a particular district. It's not limited to just one district commission. Second, each district commission shall consist of, so this is the composition, a president, B, not less than 2 and not more than such number of members as may be prescribed in consultation with the central government. The rules are yet to be confirmed. There are draft rules of 2019. So we have 1987 rules, but now 2019 rules will be coming into force soon. So what is the rule for qualification and salary? The central government may by notification make rules to provide for qualification, method of recruitment, procedure for appointment, term of service, resignation, removal, and the state government by notification will provide for salaries and allowances and other terms and conditions. So please remember that herein when the matter is with respect to their appointment, their qualification, their resignation, removal, all that will be dealt by the central government. But when it comes to the matters of salary and allowances, that will be dealt by the state government. That is the reason I have highlighted both of them. Then qualification. So qualification, see, in the 2019 rules there is rule 4 which deals with the qualification. So who can be the president? A person shall not be qualified for appointment as a president unless he is or has been or is qualified to be a district judge. So it's necessary that either he is or he has been, or even if it is he is qualified to be district judge, then such person can be the president. Second is about the member. So a person shall not be qualified for appointment as a member unless he is of not less than 35 years of age and possesses a bachelor's degree from a recognized university. And this is general, that a person should be of ability, integrity, having special knowledge and professional experience of not less than 15 years in economics, business, commerce, law, finance, accountancy, management, industry, public affairs, or administration. So it's not that each of it, it's not possible. Any of these fields, if he is an expert or professional who has worked for 15 years in any of these fields, then he can be the member of the district commission. And one of the members will be a woman. Okay, so whatever the number of members, that will be decided by the central government. Out of those members, one will be women. Then term of office. So rule 11 deals with it, says that every member of district forum is to hold office for a term of 5 years or up to the age of 65 years, whichever is earlier. And as I have highlighted it, because in the 1986 rules, or the provisions, you will see that people were not eligible for reappointment, but herein they'll be eligible for reappointment for another term of 5 years or up to the age of 65 years, whichever is earlier. Okay, then State Commission. So section 42, you can just remember the sections which at least it establishes them. So section 28 was there for the District Commission, I think, and let's check it. Yeah, section 28 is there for its establishment. Then section 42 is for the State Commission. Now the state government by notification it shall establish a State Consumer Dispute Redressal Commission, which will be called a State Commission, and it will be ordinarily functioning at the state capital and at other such places as the state government may, in consultation with the State Commission, notify in the official gazette. कंपोजिशन देखते हैं. रीजनल बेंचेस भी हो सकती हैं स्टेट कमीशन की. हाँ, तो कंपोजिशन में एक प्रेसिडेंट होगा और यहाँ पर 4 मेंबर्स से कम नहीं होगा. ठीक है, तो डिस्ट्रिक्ट में आपको याद रखना है 2 से कम नहीं होगा और स्टेट कमीशन में 4 मेंबर्स से कम नहीं होना चाहिए. क्वालिफिकेशंस देख लेते हैं यहाँ पर. So a person shall not be qualified for appointment as president unless he is or has been a judge of the high court. ठीक है, तो डिस्ट्रिक्ट कमीशन का प्रेसिडेंट होने के लिए क्या ज़रूरी है कि आप या तो डिस्ट्रिक्ट जज हैं या थे या हो सकते हैं. इसी तरह से स्टेट कमीशन के लिए क्या होना ज़रूरी है, हाई कोर्ट का जज, या तो आप थे या हैं या हो सकते हैं. ठीक है, उसके अलावा मेंबर्स के बारे में देखें तो इट शुड नॉट बी लेस देन 40 ईयर्स ऑफ एज. तो डिस्ट्रिक्ट में क्या था 35, यहाँ पर है 40. एंड पोजेसेस अ बैचलर्स डिग्री फ्रॉम रिकग्नाइज्ड यूनिवर्सिटी. और वही सारी चीज़ें इनमें से किसी भी एरिया में, यहाँ उसमें 15 ईयर्स का एक्सपीरियंस चाहिए, यहाँ पे 20 ईयर्स का एक्सपीरियंस चाहिए. उसके बाद प्रोवाइडेड दैट नॉट मोर देन 50% ऑफ द मेंबर शैल बी फ्रॉम अमंग्स पर्सनस हैविंग अ जुडिशियल बैकग्राउंड. और कम से कम 50% लोग जुडिशियल बैकग्राउंड से यानी कि लॉ के बैकग्राउंड से होने चाहिए. एक्सप्लेनेशन क्या कहता है, having a judicial background mean persons having knowledge and experience of at least 10 years as a presiding officer at the district level court or any tribunal at equivalent level. Okay, so standards are high here. So if you want to be the member of state commission, what is required is that you should have at least 10 years of experience as a presiding officer of the district level court or any tribunal or any such forum which is equivalent to it. Then one of the members of the state commission, the same provision, one shall be a woman. Then term of appointment, rule 11, it says it shall be 5 years or up to age of 67 years, and again they are eligible for reappointment. So district commission में क्या था 65, यहाँ पर age है 67. अब आते हैं highest authority which is national commission. तो यहाँ पर section 53. So we have 28, section 28, then we have section 42, and then we have section 53. So 53 establishes the national commission by the central government, and the subsection 2 says that it will ordinarily function at the national capital region and perform its functions at such other places as central government may in consultation with the national commission notifying the official gazette. उसकी बेंचेस भी हो सकती हैं अलग अलग जगह. कंपोजिशन देखें तो प्रेसिडेंट एंड नॉट लेस देन 4 एंड नॉट मोर देन सच मेंबर्स एज मे बी प्रिस्क्राइब्ड. तो 4 से कम मेंबर्स नहीं होंगे. क्वालिफिकेशन यहाँ देखते हैं, इज अपॉइंटेड बाय द सेंट्रल गवर्नमेंट आफ्टर कंसल्टेशन विद द चीफ जस्टिस ऑफ इंडिया. तो यहाँ पर प्रेसिडेंट को सेंट्रल गवर्नमेंट अपॉइंट करेगी after consultation with the CJI, and the appointment of the other members of the commission is made by the central government on the recommendation of a selection committee. अब उस selection committee के members कौन होंगे वो इतना ज़रूरी नहीं है. हम टर्म ऑफ ऑफिस देख लेते हैं. यहाँ पर it should be not exceeding than 5 years, and again they should be eligible for reappointment, and then here the age is 70 years. Okay, so 65, 67 and 70. Now the most important part of these redressal forums is about the jurisdiction. Now the term jurisdiction, if let's try to define it, we can say that it means as authority or legal power to hear and decide the cases. Thus, a court may adjudicate not only those matters which fall under its jurisdiction. The question of jurisdiction has to be considered with reference to the value, place and nature of the subject matter. ठीक है, तो jurisdiction का power है, मतलब है legal power to hear and decide the case. Okay, it's a very basic definition और आप सबको पता होगी ये, और नहीं पता तो आप याद कर लीजिए. Thus, a court may adjudicate only those matters which fall under its jurisdiction. और jurisdiction को determine करने के लिए ये सारे factors हो सकते हैं, value, place या nature of the subject matter. General rule is that if the court rendering the judgment suffers from want of jurisdiction, its judgment is nullity and may be ignored. ठीक है, तो जब कोई भी कोर्ट बिना jurisdiction के judgment देता है तो उसका judgment will be considered as nullity. Jurisdiction of consumer forums या consumer courts, they differ in terms of monetary value of claims, geographical area and appellate powers. So let's analyze the jurisdiction of these forums. सबसे पहले district forum की बात करें या district commission की, उसका pecuniary jurisdiction जो है now after the 2019 act is that it can entertain the complaints where the value of the goods or services paid as consideration does not exceed 1 crore rupees. ठीक है, पहले क्या था, पहले जो है वो गुड्स और सर्विसेज के ऊपर जो कंसिडरेशन पे किया उसके ऊपर पे डिसाइड नहीं होता था उसके बेसिस पर, बल्कि आपने जो क्लेम किया है कोर्ट में उसके बेसिस पर डिसाइड होता था, एंड विच वाज ओनली 5 lakhs. तो मतलब ये है कि सपोजली अगर आपने एक कंप्यूटर लिया और उसका आप जो प्राइस है मान लीजिए अगर 50,000 है और आपने कुछ टाइम यूज़ किया उसे और उसके बाद में उस फंक्शनिंग उसकी ख़राब हो गई, बंद हो गया वो, तो आपने अगर क्लेम किया वो था 40,000 का, तो क्लेम के बेसिस पर जुरिस्डिक्शन होता था, ना कि वैल्यू ऑफ गुड्स एंड सर्विसेज के ऊपर. अब जो जुरिस्डिक्शन है कोर्ट्स का वो कंसिडरेशन के ऊपर है गुड्स एंड सर्विसेज का, और जो काफ़ी अब इंक्रीज कर दिया है. नाउ द लिमिट इज़ 1 crore rupees इन द डिस्ट्रिक्ट कोर्ट इटसेल्फ, डिस्ट्रिक्ट फोरम इटसेल्फ. ओके, so that's the pecuniary jurisdiction which is given under section 34 of the act. Then we have territorial jurisdiction. So this is also very important कि आप complaint कहाँ file करेंगे, कहाँ file कर सकते हैं. तो a complaint shall be instituted in a district commission within the local limits of whose jurisdiction 1. The opposite party or each of the opposite parties where there are more than one at the time of the institution of the complaint ordinarily resides or carries on business or has a branch office or personally works for gain. तो जहाँ जो है डिफेंडेंट यानी कि जिसके अगेंस्ट में आपने कंप्लेन की है, सेलर, मैन्युफैक्चरर या ट्रेडर, उसका होना या तो आप जहाँ भी कंप्लेन फाइल कर रहे हैं या तो उस जगह पे वो ऑर्डिनरी रिसाइड करता है, अपना बिजनेस करता है, या उसका ब्रांच ऑफिस है, या वो पर्सनली वर्क करता है फॉर गेन. बी जो है कहता है अगर कोई भी एक अपोजिट पार्टी प्रेजेंट हो तो आप वहाँ भी केस फाइल कर सकते हैं, लेकिन उसके लिए आपको डिस्ट्रिक्ट कमीशन की परमिशन लेनी पड़ेगी. ठीक है, मान लीजिए अगर एक से ज़्यादा पार्टी हैं और उनमें से सिर्फ एक ही पार्टी बॉम्बे रिसाइड करती है, बाकी दिल्ली रिसाइड करती हैं, तो आप अगर बॉम्बे में केस फाइल करना चाहते हैं तो आपको उसके लिए परमिशन लेनी पड़ेगी डिस्ट्रिक्ट कमीशन से. अगर सारी ही पार्टीज़ एक जगह होती हैं तो आप डेफिनेटली वहाँ केस फाइल कर सकते हैं, तब तो कोई इशू नहीं है. ठीक है। सी कहता है कॉज ऑफ एक्शन जहाँ होली और इन पार्ट अराइज करता है। तो आपने कहीं कॉन्ट्रैक्ट, अगर जैसे आप लॉ ऑफ कॉन्ट्रैक्ट में पढ़ते हैं कॉज ऑफ एक्शन कहाँ अराइज हुआ है, वहाँ पे जैसे केस फाइल किया जा सकता है। इसी तरह से यहाँ पे भी जहाँ कॉज ऑफ एक्शन अराइज हुआ है आप वहाँ केस फाइल कर सकते हैं। सबसे इम्पॉर्टेंट पार्ट जो है, जो अभी 2019 एक्ट में इंक्लूड किया है, वो है कंप्लेनेंट जहाँ रिसाइड करता है या पर्सनली वर्क करता है। तो पहले क्या होता था, बहुत प्रॉब्लम्स होती थी कंज्यूमर्स को, और इसीलिए बहुत सारे लोग कंप्लेंट फाइल नहीं भी करते थे। उन्हें लगता था कि आने जाने में ही ट्रांसपोर्टेशन में इतना खर्चा हो जाता था। तो अब आप जहाँ रिसाइड करते हैं या आप जहाँ काम करते हैं वहाँ के भी डिस्ट्रिक्ट कमीशन में, वहाँ के डिस्ट्रिक्ट फोरम में आप केस फाइल कर सकते हैं। तो ये एक बहुत ही लॉडेटरी प्रोविज़न है। इट्स अ वेरी वेलकमिंग प्रोविज़न which has been included in the 2019 Act, which I have highlighted also. फिर है पावर ऑफ रिव्यू। तो डिस्ट्रिक्ट कमीशन के पास भी पावर है दैट कैन रिव्यू एनी ऑफ द ऑर्डर दैट इज बीइंग पास बाय इट, अगर उसे लगता है, लेकिन जो स्टैंडर्ड है वो हाई है। इफ़ इट फील्स दैट द ऑर्डर दैट इज बीइंग पास बाय इट is having is an error which is apparent on the face of the record, then it can by itself or an application that is being made by the parties within 30 days of such order, it can review the order that is being passed by it. Okay, now let's come to the state commission. State commission का pecuniary jurisdiction है 1 crore to 10 crore rupees, ठीक है। और कंप्लेन जो है अगेंस्ट अनफेयर, क्योंकि अनफेयर कॉन्ट्रैक्ट जो है फर्स्ट टाइम इंक्लूड किया गया है 2019 एक्ट में। पहले कॉन्ट्रैक्ट्स के जो केसेस होते थे अनफेयर कॉन्ट्रैक्ट्स के, वो सिविल कोर्ट्स में जाते थे, लेकिन अब अनफेयर कॉन्ट्रैक्ट्स के केसेस भी कंज्यूमर फोरम्स में फाइल किए जा सकते हैं, ठीक है। तो दोनों ही केसेस में 10 करोड़ से ज़्यादा लिमिट नहीं होनी चाहिए। तो 1 to 10 करोड़ केसेस विल बी डेल्ट इन द स्टेट कमीशन। टेरिटोरियल जुरिस्डिक्शन इसका वैसा ही है जैसा डिस्ट्रिक्ट फोरम का है, सेम, ठीक है, वही है। कोई एक पार्टी रिसाइड करती है या सारी पार्टीज़ एक ही जगह रिसाइड करती हैं तब तो कोई प्रॉब्लम नहीं है, आप वहाँ केस फाइल कर सकते हैं। कोई एक अपोजिट पार्टी रिसाइड करती है तो आप वहाँ भी फाइल कर सकते हैं परमिशन लेके। कॉज ऑफ एक्शन जहाँ राइज हुआ है या आप जहाँ खुद रहते हैं या काम करते हैं वहाँ केस फाइल कर सकते हैं। तो टेरिटोरियल जुरिस्डिक्शन तो स्टेट कमीशन का डिस्ट्रिक्ट कमीशन की तरह ही है। अपीलेट जुरिस्डिक्शन की बात करें तो डिस्ट्रिक्ट कमीशन ने जो ऑर्डर्स पास किए उसके अगेंस्ट में आप अपील स्टेट कमीशन में फाइल कर सकते हैं। फिर रिविजनल जुरिस्डिक्शन क्या है? रिविजनल है where you can call for the records and pass appropriate orders in any consumer dispute which is pending before or has been decided by any district commission within the state. तो जब कंज्यूमर डिस्प्यूट पेंडिंग है या डिस्ट्रिक्ट कमीशन ने पहले से डिसाइड कर दिया है और स्टेट कमीशन को लगता है कि डिस्ट्रिक्ट कमीशन ने जो जुरिस्डिक्शन एक्सरसाइज किया था वो इट वाज नॉट एक्चुअली वेस्टेड इन इट बाय लॉ, या it has failed to exercise the jurisdiction that was vested in district commission, or it has actually acted in exercise of its jurisdiction illegally or with material irregularity, ठीक है। तो या तो केस पेंडिंग हो या फिर ये जो 3-4 ग्राउंड्स हैं इन पर स्टेट कमीशन को लगता है कि ये फुलफिल हो रहे हैं, कि आपने जुरिस्डिक्शन एक्सीड कर दिया है या इलीगली एक्सरसाइज किया है या एक्सरसाइज ही नहीं किया है या कोई मटेरियल इरेगुलरिटी है उस जुरिस्डिक्शन को एक्सरसाइज करने में। इन सारे ही सर्कमस्टांसेस में स्टेट कमीशन डिस्ट्रिक्ट कमीशन से वो केस को विड्रॉ करके खुद डिसाइड करेगी केस, और ये है रिविजनल जुरिस्डिक्शन, ठीक है। अगर आप चाहें पढ़ सकते हैं, टू कॉल फॉर द रिकॉर्ड्स एंड पास अप्रोप्रिएट ऑर्डर्स in any consumer dispute which is pending before or has been decided by any district commission within the state, where it appears to the state commission that such district commission has exercised a jurisdiction not vested in it by law, or has failed to exercise a jurisdiction so vested, or has acted in exercise of its jurisdiction illegally or with material irregularity. Okay, then the power of review. रिव्यू जैसे डिस्ट्रिक्ट कमीशन के पास है पावर रिव्यू की, वैसे ही स्टेट कमीशन के पास भी है. If it feels that the orders that are being passed were an error which were apparent on the face of record, so either by itself or when a complaint is filed, it can review its order. Now finally, the National Commission. तो नेशनल कमीशन का पिक्यूनरी जुरिस्डिक्शन है above than 10 करोड़ रुपीज़. इसी तरह से अनफेयर कॉन्ट्रैक्ट्स के केसेस में भी इफ इट्स above than 10 करोड़ यू कैन गो टू नेशनल कमीशन. Appellate jurisdiction है against the orders that are being passed by the state commission या central authority. अब territorial jurisdiction तो इसका है नहीं. territorial jurisdiction से मतलब है कि सारे ही cases इसके पास आ सकते हैं और सारा ही एरिया, सारा ही जो jurisdiction है इंडिया का वो नेशनल कमीशन एक्सरसाइज करती है स्टेट ऑफ जम्मू एंड कश्मीर को छोड़ के. बट हाँ, कंज्यूमर प्रोटेक्शन एक्ट जो है इट्स एप्लीकेबल ओनली इफ कॉज ऑफ एक्शन अराइजेज इन इंडिया. तो अगर कॉज ऑफ एक्शन इंडिया के बाहर अराइज होता है तो नेशनल कमीशन का कोई जुरिस्डिक्शन नहीं होगा. डिविजनल जुरिस्डिक्शन बिल्कुल वैसा ही है. ये अगर नेशनल कमीशन को लगता है कि स्टेट कमीशन ने कोई भी केस डिसाइड किया और उसका जुरिस्डिक्शन नहीं था या एक्सीड किया जुरिस्डिक्शन को या फिर इलीगली एक्सरसाइज किया, तो उन सारे केसेस में it can call for the records and then it can itself pass the appropriate orders. ठीक है. फिर वही पावर ऑफ रिव्यू भी है कि सेक्शन 60 में कि अगर ऑर्डर्स जो हैं दे आर erroneous and they appear, the same appears on the face of the record, then definitely either by itself or when there is a complaint, then it can review the order passed by it. Remember the time, within 30 days of the order. Okay, so this is all about the authorities under the act. So you have to remember there are three major authorities and what is the different kind of functions, the powers that are being exercised by them, and most importantly about the consumer forums of district, state and national commission, what is their jurisdiction, and specifically their pecuniary and territorial jurisdiction, and the other jurisdiction you can remember. So thank you, wish you all the best, and please revert back when if you do not understand anything. Thank you so much.